Well, hello everyone, and welcome to the review for exam number two. Uh, as I sit to record this review session, it's a little bit dark, a little bit gloomy, a little bit wet outside. Hopefully, while you're watching this, maybe it's brighter. I came to my office, watched the end of the football game. A little disappointing, but I'm optimistic. Maybe we'll have a better weekend next weekend. And I know that for many of you, this is midterms. These are exam weeks. These are paper weeks. I guess there's no difference in the fact that you have an exam in this class. And my objective with this review is to try to minimize any anxiety that you have. I'll probably add to it with the first thing that I'm going to say, but my hope is that will reduce any stress that you have as you prepare for this exam. As I said, I'm sitting in my office. I completed writing exam number two. I will be perhaps tweaking it a bit, but watched the football game. Was a little disappointed, particularly in the fourth quarter, but the game that matters to me the most always is the one that's coming up next weekend. And let's get our exam work behind us. Hopefully, you'll be able to enjoy the festivities of next weekend. And then I think as I look at the schedule, you get a couple of days of break as well. So make sure you get rest. Make sure that you enjoy the time that you have as a student. And let's see if we can get you to a good, successful result in the second exam. The second exam is over torts, and you will probably note that of all of the exam topic lists that I provide to you, this one will be the shortest. I try to have each of the exams be fairly equal by way of difficulty, and I believe that the most challenging material for students is the tort material. You've heard me mention multiple times that it, to me, is the most challenging because it is the most subjective. It takes the ability for you to apply the principles of tort law to a particular set of facts and reason your way to the successful answer. I've always believed, particularly when taking objective questions, that it is equally important for you to be able to articulate to yourself why the answers that you are not selecting are incorrect, and as you reason your way to the correct answer. I don't necessarily look at the options, see what you think is the correct answer, grab it, move on, without being able to articulate why the other responses that you are not selecting are incorrect. The exam will open up on Wednesday, October the 18th at 8 a.m. Same format that you saw with the first exam. It will have two parts to it. Both of those parts are equally weighted. Part A are the objective questions. You'll see more application-based questions on this exam, where I take facts and have you apply the law to those facts to reason your way to what should be the accurate outcome, the correct response, the best response. And then there's the part B, which are the subjective questions. And here also, you're going to have some fact-based questions for you to apply the law to those fact-based questions. Part A, the objective questions, will open at 8 a.m. They will close at 8 p.m. on Wednesday. So you have to give yourself enough time to be able to actually complete those 25 objective questions. And so you're going to want to start the exam and give yourself at least an hour. You'll have 60 minutes to complete those objective questions, unless certainly the RCPD applies to you, and then you'll have the additional time. I don't think time was an issue. At least most people didn't report concerns about the time on the objective questions. And if that is a circumstance, if that is an issue for you, please give me some feedback on that. The Part B questions, the subjective questions, the essay responses, I'm going to have those open for you from 8 a.m. on Wednesday, October the 18th, all the way to 11:59 p.m. on Thursday, October 19th. That'll all be in the explanations to the exam as well. But as I said, it's kind of the same format as you had with exam number one. It's open book, it's open note. I expect you to do your own work. Believe me, there are means to figure out if that's happening or not. Again, there's multiple different questions, multiple different variations of those questions. I'm not blind to the fact that always in academic circles there are people that will try to cheat. It never pans out. It never works out for them in the long run. And on something like this, where it is open book, open note, open slides, you're really just cheating yourself in taking a risk that is absolutely not worth taking, and don't do it. Do your own work. As I said, we get reports from time to time where people will be taking the exam at the same time. They'll have kind of the same iterations of responses, and you realize what's happening, and that's unfortunate for all those involved. So if you look at the topic list for this exam, as I mentioned to you, it's the briefest of the lists because I think that the application of these concepts can be the most challenging of the course. I'm not intending this review to be a lecturing of all of the lectures that I did on torts for you, but let me spitball at you kind of what jumps out at first blush when I look at those topics, and perhaps this will help you hearing from me one last time what it is that I think is important about these concepts. Tort law, as we have talked about, is another way of enforcing obligation, another way of enforcing duty. It's another way of thinking and establishing responsibility, obligation, duty, law. It is the most subjective manner upon which we establish our duty to our fellow humans. In as much as we understand, and we've talked about statutes that create legal obligation, contracts that create legal obligation. But with tort law, we look at this much more broadly, and we recognize that you heard me during lecture talk about, a contract with society. The reality of it is that when our behavior can put others in harm's way, that we have a obligation to act with reasonable care for the safety and welfare of others, and if we botch that, if we violate that obligation to act with reasonable care for their safety and welfare, and we cause them harm, we can be held liable, even though there may not be a statute that establishes how we are to have acted, or a contract that creates a legal relationship between ourselves and those whom it is that our behavior, our actions have caused harm to. The legal obligation cannot be something that is established or exists but for our behavior. We have to engage in some behavior that has put others at risk. And when we engage in that behavior, we have an obligation to act with care in how we conduct ourselves and our affairs, such that we minimize the likelihood of harm or risk to others. I gave you the example of, you look at someone like me, who doesn't grow his own food, prepare his own food, but certainly loves to consume food. That is a great measure of trust that I place in the producers and those who make my food. I eat in many different local East Lansing dining establishments, and it's a measure of trust that I have that those who are in the stream of commerce all the way to bringing that food to my table are acting with reasonable care for my safety and welfare. I may not have privity of contract. I may not have a contractual relationship with all of those parties, but I am trusting that they are conducting themselves within the standard of care to protect myself from becoming ill based upon what it is that I consume. We leave our houses each day, and we put our safety, our welfare into the hands of total and complete strangers. When we're driving our vehicles, when we are engaged in almost every type of behavior, that if we do so in a poor manner, we can harm others or their property, then the likelihood is that we owe an obligation to minimize the risk of harm to those individuals. The objectives, the purpose of tort law is those who are at fault for causing the harm to others should be financially responsible for the harm that they cause. And this is really fair. It's also a way of trying to motivate particularly businesses to spend some time and effort and resources to, again, safeguard those whom their products, their services, their behavior could cause harm to. So when we have the concept of a tort, the civil wrong, the ability for those who are harmed due to the alleged wrongful behavior of others, they may seek compensation. And when the unlawful act is deemed to be tortious, this opens up the availability for non-economic damages as a measure of recovery. Pain and suffering can be compensated where we didn't see that as a possibility when there was, say, a breach of contract creating the alleged unlawful conduct. So we take this concept of tort and we divide it really into three categories: the intentional wrong, the negligent wrong, and then the strict liability tort, which is where we will actually hold someone responsible despite the fact that we are not able to establish that they have necessarily done anything wrong. The intentional tort is where we focus in on the unlawful actions of the alleged tortfeasor, the alleged wrongdoer. And recall that you can have unlawful action that is not criminal in nature, all the way up to and certainly inclusive of criminal acts. And when you have a crime to which there is a victim, by definition, you have also an intentional tort that is present. Whoever is the victim of a crime has been a victim also of an intentional tort. Why? Because if we have a crime that has been committed, we have established that an illegal act has occurred, and we've established that beyond a reasonable doubt. Well, if we've established beyond a reasonable doubt that an illegal act has occurred, then by a preponderance of the evidence, the civil standard, we have also established that an intentional wrong has been committed if there is a victim of that illegal act. And so many of the intentional torts that we viewed, that we looked at, that I addressed, assault, battery, are reflective also of what could have been a criminal act against the victim. Some of the intentional torts, defamation by way of example, is not a criminal act, but nevertheless, defamation, when it's against when it's a private party that has been defamed, a non-public figure, is categorized as an intentional tort. If you recall the lecture slide on the spectrum of fault that I presented to you, what is noteworthy and a key distinction between intentional torts and negligent torts is how we treat harm. When it's an intentional tort, establishing an objective injury, an objective harm, objective evidence of damage is not a requirement. It is not a prerequisite for the establishment of an intentional tort. It's not what we refer to as part of the prima facie case of establishing an intentional tort. We will infer that there has been harm if someone is the victim of an intentional wrong. Whereas if it's a negligent tort, one of the measures, one of the objective standards, one of the elements of negligence is that there be objective evidence of harm, actual damage that is established. I'm not going to go through with you the intentional torts. Certainly, I think you should have the lecture slides available to you when you take the exam. I think you should review the intentional torts. Assault, battery, defamation, false imprisonment certainly all make their way onto the exam. I don't think those are the most complicated questions that you'll run into because it's really applying the elements to a particular set of facts. And that's probably as an objective in the area of tort law as exists. Negligence is where one engages in unreasonable behavior, causing harm to others, and owed a duty to have acted with reasonable care for the welfare and safety of those whom it is that they have harmed. Because this is the most subjective concept that we have within law, we place some guardrails, some elements that all must be established for a finding of the tort of negligence. And those elements are duty, breach of duty, causation, damage. Certainly, you'll want to look at the lecture slides on those four elements. I spoke at length about those elements. The concept of duty is to whom it is that we owe a legal duty to act in a particular manner or even refrain from acting in a particular manner. And the concept of duty is consistent with who's in the zone of danger. If we act in a negligent manner, who is it that it is reasonably likelihood that our actions may cause harm to? Breach of duty is really the question of have we acted in an unreasonable manner? The law mandates that we act in a manner that is consistent with how a reasonably prudent person would act under the same or similar circumstances. And that's really the test of negligence. Is there a cause and effect relationship between the breach of duty and the resultant harm? And then finally, damages. Are there objective evidence of damages? And that must be present for the tort of negligence to exist. I gave you examples of how we have all acted in a manner from time to time that is negligent. But we have not committed the tort of negligence, fortunately, because there hasn't been harm as a result of our behavior. You look down at your phone while driving your car. That is a absolutely unreasonable act. So many of us have done that. It is negligent behavior. But fortunately, if there hasn't been an accident, if there hasn't been impact, we haven't committed the tort of negligence. We've committed a violation of the law. We should be ticketed. We will be ticketed. We shouldn't engage in that conduct. Shame on us for doing so. But it's the example that I give, or an example I give of the difference between acting unreasonably and having actually committed the tort of negligence. In fact, engaging in that behavior probably pushes us even further into the realm of an intentional wrong, particularly now that we have laws that restrict our usage of devices while we are driving our car. There are other issues within the law of negligence that we talked about, I think, that are worth reviewing before the exam. The eggshell skulled plaintiff rule: you take your victim as you find them. While the person whom is owed a duty should be reasonably foreseeable, how they are injured does not have to be reasonably foreseeable. And we are responsible to our victims for the full extent of the harm that occurs to them, the eggshell skull plaintiff rule. We talked about the comparative fault, the fact that juries can assess some fault upon and toward the plaintiff in a case, and we reduce the amount of damages that the plaintiff sustains proportionate to their own measure of fault for the event that has caused them harm. Some of the defenses to negligence that we looked at are assumption of the risk, governmental immunity, things that can minimize or reduce the possibility that there is an act of negligence. Not a lot on the exam about that, but it's certainly something that terminology-wise you want to look at. We then looked at some other issues as it relates to the concept of negligence. I'll skip ahead just a moment and point out the difference between direct liability. I have acted negligently and I am responsible for my act of negligence, and imputed liability. I have acted negligently and my negligence will be imputed to my employer. Remember that when someone acts negligently, they are always fully responsible for their act of negligence. So the employee who has acted negligently, the employee that has dropped the tray on the head of the unsuspecting patron, the employee is always fully responsible for his or her or their act of negligence. The question is, can that also be held against the employer? And don't be confused. If the damages that are assessed to or for the benefit of a plaintiff are, $100,000, and the employee is found to be fully responsible, and so is the employer, then this will create what we refer to as joint and several liability, where the victim can collect the full amount from either the employee or the employer. They can't collect more than what the jury awards, but the concept of imputed liability doesn't remove liability from the direct negligent party. We also talked about the fact that we don't want employers using as a defense, well, I didn't tell my employee to go act negligently. And so we have the concept of frolic and detour, that if the employee is acting within the scope of employment or a minor departure, a minor deviation from the scope of employment, which what we refer to as a detour, the employee and the employer will be responsible for the act of negligence. If it's an out-and-out frolic, which is a major departure from the scope of employment, we will not impute liability. So in other words, if the employee is doing something way beyond the scope of what his or her or their employment was, we will not impute liability. We will deem that to be a frolic. Finally, we talked about the kind of exceptions to fault-based liability, strict liability, where unreasonably dangerous actions, activities, businesses, abnormally dangerous, super hazardous activities, we will impute, we will strictly hold those who engage in that behavior liable without actually a determination of fault. If there is harm as a result of an abnormally dangerous business practice, the business that engages in that practice will be at fault, even without an establishment of doing something wrong. And this is just simply, as a matter of public policy, part of the cost of doing business. If you're involved in an abnormally dangerous activity, is you're responsible for the harm that occurs. How could anyone insure against, say, an oil or gas catastrophe or spill? And then we talked about workers' compensation and no fault, where we separate out economic damages from non-economic damages. if the injury occurs as a result of a work event, repetitive conduct, a traumatic injury that occurs to an employee within the working environment, the employer is mandated to have workers' compensation insurance, and the workers' compensation insurance and the insurance policy is the exclusive remedy for the injured employee. The good news for the employee, there shall be the payment of benefits. The bad news for the employee is the payment of those benefits will be limited to economic damages, payment for medical bills, payment for replacement services, payment for lost wages, or more likely a percentage of lost wages in most jurisdictions, but nothing for pain and suffering, no non-economic damages if it's a work-related event. In a state like Michigan that employs the no-fault scheme for automobile crash circumstances, same theory, the separation of economic damages from non-economic damages. As to all economic damages in Michigan, we turn to our own insurance carriers to provide payment for the non-economic damages that have been, for the economic damages that have been lost. Let me say that again, because I misspoke. We take automobile accidents and those who have lost economic benefits, those who have lost wages, those who have medical bills, those whose cars have been harmed. We turn for all economic loss to our own insurance carriers. These are what are referred to as first-party claims. We turn to our own insurance carrier. I struck your car. You still turn to your own insurance carrier for there to be replacement or fixing that vehicle based upon your insurance contract. We don't litigate fault in most automobile crash cases because we do not award pain and suffering in most automobile crash cases, and we only allow for a determination of should there be payment for pain and suffering to a victim in an automobile accident if a threshold is met. And that threshold that we talked about during our overview of this substantive material was death, serious and permanent impairment of an important body function, or serious and permanent disfigurement. Disfigurement, death, or serious impairment of an important body function. If that exists, then the person who is the victim of death, serious impairment of an important body function, or permanent disfigurement, and if it's death, then it's obviously going to be the family of the individual. But when the threshold is met, then and only then will we go forward, or can we go forward with a determination of who's at fault. And that's where we'll have a negligence action. That's where the at-fault party, or more likely their insurance carrier, could be responsible for paying pain and suffering, non-economic damages. Really, if you've made it this far in the review, you're probably entitled to a little bit of a bonus. Let me tell you this, on no fault, the only thing that I test is the threshold. If you know what the 3 threshold injury classifications are that would allow for a determination of fault, death, serious and permanent impairment of an important body function, or permanent disfigurement, if you got that, you're going to sail through that question. I think it's important to have a working knowledge of the no-fault scheme, but I'm not expecting much other than to recognize that in a state like Michigan, we handle these matters differently, and we remove them from the traditional tort system, which is different than how most states handle car crashes. The objective is to try to get money into people's hands quicker and having them turn to their own insurance carriers and not have to litigate the issue of fault was the motivation back in 1972 for the no-fault statute in Michigan to be adopted. The good news, you do well on this exam, you're going to do well in the class. Because I think that the material that is coming toward you and at you in the second half of the class is the easier material. You don't do as well as you'd like to on this. Revert back to what I just said. The easier material I think is coming. So how do you do well on this exam? Honestly, I think you try to minimize any anxiousness that you have about the terminology. I think you try to look at each of the questions and think, really what would be the just right outcome. I think you try to approach it rested. Don't overthink yourself. Again, be able to eliminate the wrong responses as you narrow in or focus in on what you think is the correct response. Remember that when you get that objective score, that part A score, that's only half of the exam. I get emails from people at 10 o'clock in the morning, 11 o'clock in the morning. I didn't do as well as I thought I was going to do. And I try to remind them, hey, that's only half of the exam score at this point in time. So don't be one of those people that emails me that. You can email me anytime you want on a question, but keep your poise, keep calm. And if you do that, I think you'll have success. At the end of the day, also remember that this should be as important. I know grades are important. I was a student at Michigan State, and grades were important. But learning this material, being able to get an assessment of where you're at, really in the long run is more important. Probably if I could go back, I would have focused a little bit less on the grade, probably a little bit more on the takeaway, the learning. But I also remember what my mindset was and my thought process when I was 20, 21, 22 years old. So have a great rest of your weekend or a great week ahead. I will lecture and start posting the material that will be on exam number 3 so that we'll lose any momentum. But anything that I can do to assist you, don't hesitate to reach out. And don't let this day go by without thinking of someone that that doesn't have it as good as you, maybe somebody that's struggling a little bit, maybe somebody's a little bit lonely. Shoot them a text. Message them in whatever fashion that you message, and let them know that they're thought of. I don't care how busy you are, you're not too busy to make an effort for somebody that might be struggling. It's going to make their day better. It's going to make your day better. So remember, we exist because of you, the students. Good luck on the exam. As is always the case, people have technical glitches. Reach out to me and let me know. And as always, go green.